Hi, my name is Jennifer Mott. I'm an attorney with the law firm of Aspey, Watkins & Diesel in Flagstaff. I practice in the areas of business law, including some intellectual property, as well as real estate. What I'm here to talk to you about today is lessons that I've learned working business divorce cases. Now, as part of my business law practice, I work with new businesses, getting them off the ground, forming the entities, and then eventually that evolves into corporate counseling over time. On the flip side, I also work with businesses that have reached a point where they can no longer work together and the owners have to find a solution and get out. So I do have to say, because I'm a lawyer, I've got to do the disclaimer, this is not legal advice. This is for informational and educational purposes. I'm going to share some stories today. In addition to being a lawyer, I consider myself a small business owner. Prior to my time at Aspey, Watkins & Diesel, I spent about 9 years with one other lawyer building a law firm from the ground up. And while I'm appreciative of the firm that I'm at now, I also have a background as a small business owner. So as I stand here and talk to everybody today, I come at you with this background, both the legal background and the small business owner. I enjoy working with the entrepreneurs and the startup companies. I find their innovation, their excitement, and their enthusiasm for what they're doing to be a lot of fun. So today, I'm going to take what I've learned as a small business owner and a lawyer, and I'm going to talk about lessons that I have learned. Before I get into the lessons learned from business divorce, I think I need to explain what I mean by a business divorce. This isn't a husband and wife that have to decide who gets what business interests. This is when the founders or the owners of a company reach an impasse. They can no longer cooperate and act as a cohesive unit. Instead, things tend to devolve, and more time is spent focusing on what's wrong instead of building the business. So by the time the business divorce clients get to my office, there tends to be some problems and some animosity and a lot of emotion that gets built up. So the two most common structures that we see for startup companies and for small businesses are going to be corporations and limited liability companies. Now, a corporation is owned by shareholders, governed by a board of directors, operated by officers, and when there's money to share, that gets paid to the shareholders as a dividend. The agreement that governs the relationship between these parties is called the bylaws. Now, on a limited liability company, the owners are going to be called members. There may or may not be a manager. It depends on the structure. There are member-managed LLCs and manager-managed LLCs, and that tends to be a mouthful. I interchangeably use the term partner because it flows a little bit more easily. When the owners of the business get paid, they're paid in something called distributions, so dividends and distributions. And I note that there may be an operating agreement for your limited liability company, in part because there are some new changes to the LLC Act that we'll talk about later, where even if your operating agreement isn't called an operating agreement, you still may be bound by the terms of a writing or maybe even a verbal agreement. So what I hope to do today, regardless of your corporate structure, regardless of the form of entity that you have, find some themes and some ideas that will help you and your business partners build a successful business and avoid problems down the road. My first lesson is consult a CPA. It's really easy to form a business. There's some filings that you do with the Arizona Corporation Commission or maybe the Secretary of State, depending on the state that you're in. And it's really easy to sign off on a template that you get from LegalZoom or something that you find online. There's a lot of great resources out there. But I always recommend, one of the first things I recommend to my clients before we even decide on a business entity is to consult your CPA. Let's make the best use of this tax treatment that your company is going to get. And what we can do as the lawyers is we can craft around it. With the corporations, with a limited liability company, with the flexibility of contracting, there's a pretty good chance that we can build a structure that meets your tax goals. Additionally, I highly encourage my clients to get their books set up properly. A lot of folks come in with experience. They've got bookkeepers, that's part of someone's contribution to the company, to the startup. But having the advice of a certified public accountant can get your books set up properly in the first place. Now, a lot of people say, well, it's expensive, I don't really need it. It's a lot less expensive to consult with a CPA than it is to pay a tax attorney 10 years down the road when things go wrong. That's one of my first examples I'm going to share with you today, is a company that was very successful. They did well for 10 years, but they had mischaracterized their salaries and their dividends. So as the years went on, this tax liability built up. So by the time they got to me and the members had reached a point where they could no longer cooperate, we open up the books and discover this really big tax liability. In addition to having all of the issues with the two partners that have reached an impasse, we now have the tax liability. So we get the tax lawyer involved, and that just makes one more problem that 2 or 3 owners that are having difficulty with now have to deal with. Next lesson in avoiding a business divorce is to know the defaults. What is it you're buying into when you file your articles of organization or your articles of incorporation? The Arizona Corporation Commission is where you're going to find your regulatory, administrative rules and regulations. But the real meat and potatoes of your rights and obligations as a business owner or a business investor are going to be found in the Arizona statutes. And we've got the ones listed here for corporations and limited liability companies. In the event that you have opted for a partnership structure, there's that option as well, and those are governed by the statutes. So importantly, one of the things I'm going to touch on today is the new LLC Act. This is important to not only new companies that are being formed, but also older limited liability companies because of some of these significant changes. So after September 1st, 2020, the new Arizona LLC Act applies to all limited liability companies organized in the state of Arizona. So whether or not you're a 20-year-old company or a 2-year-old company, you are bound by these new rules. Now, a lot of companies may already have an operating agreement, a well-drafted operating agreement that talks about the relationship between the managers and the members and their different areas of responsibility and how they're going to vote and how distributions are going to work. But if the operating agreement is silent as to anything covered in the new statute, the new statute's going to apply. The statute recognizes that pre-existing operating agreements may still be valid and enforceable if they were valid and enforceable under the prior act. The problem is, if the operating agreement doesn't address a particular topic, it's silent on it, then the LLC Act is going to fill in the blanks for the business owners. That can be good, that can be bad. The problem is, it may not meet the partner's expectations. It may not match up with what they have been doing all along the way. So there are some very important places where the new act is different from the old act, and I'm going to highlight a couple of those. And it is in this context where the operating agreement that you agreed to a couple of years ago was drafted, and now the landscape has changed. So we're going to look at a couple of those examples. So even if a company has an operating agreement, we highly recommend that you revisit it, take another look, and make sure that it still meets your partner's expectations. One of the biggest changes between the old and the new Limited Liability Act is the fiduciary duty. Now, corporations have had a fiduciary duty. Their directors and officers have an obligation to put the interests of the company before their own. Now, that doesn't mean that a director and officer also can't benefit by the decisions that they're making, but it's putting the interests of somebody else first, of the company, of the shareholders. Now, under the old LLC Act, there was no fiduciary duty written in. It's in stark contrast to what we're used to with the corporations. And over the years, as cases started trickling through the court system, the court started building in some kind of fiduciary duty, some kind of obligation that members and managers had to one another and to the limited liability company. Now, day in and day out, this is probably not going to be something that most owners are going to contemplate. It's a vague idea, fiduciary duty. But when problems arise, this is one of the first things that the attorneys are going to look at when figuring out who's entitled to what in a company, the fiduciary duty. The breach of fiduciary duty claim is the path to exercising a member's rights or protecting their interests in the company. So under the new LLC Act, a direct action is expressly recognized. And a direct action means that one member can sue another member, can sue a manager, or can sue the company in order to enforce their rights or hold other people to their obligations under either the operating agreement or the statutes. So the big difference now is previously there was essentially no fiduciary duty. The members, the managers could take advantage of corporate opportunities. They could, they could do all kinds of different things that if there was a fiduciary duty in place, they would be breaching. Now, it's not only that there is a fiduciary duty applied automatically under the new LLC Act, it is that it's a fairly high duty. For members in a member-managed LLC or managers in a manager-managed LLC, so anybody that has the authority to bind or act on behalf of the company is going to be held to a higher standard. They're going to have both a duty of care and a duty of loyalty. There's nuances between the two, but in short, the duty of loyalty means that the partners can't compete. Well, that may make sense on the surface. You can't compete with your company. You can't compete with your other owners. But what about the situation where there's multiple business interests spread across several different companies, and the one owner's invested in all of them, operating in all of them? Under the default rules, that could be viewed as a breach of the duty of loyalty simply by being in an industry and being a member of two of these different companies that are operating in the same space. So this is something very different than what was in place before. So when I talk about revisiting your old operating agreement, this is one of the main reasons, because there was no duty before. So why would a lawyer write out a fiduciary duty if it didn't exist in the first place? And that gets me to another point about operating agreements and the Limited Liability Company Act. With few exceptions, the owners have the opportunity to agree to something other than what's in the act. So this gives them the opportunity to structure, to have some freedom in the way that they want to operate their business. But if they're not agreeing, then the default rules apply. So there is some flexibility to back off of some of these rules. The duty of fair dealing, of good faith and fair dealing, that is something that cannot be written out. It's one of the baseline, you have to deal fairly with everybody. Another provision in the new LLC Act that may catch some people off guard is distributions. That payment made to owners simply by being an owner, not a salary that they have to earn. So let's take ABC Enterprises, not the most creative company name, but let's say member A owns 70%, B owns 20%, and C owns 10% of the company. And on a side note, with an LLC, it always has to equal 100%. 100% of the company always has to be owned. That's slightly different than corporations where they can hold back some stock, but in the LLC, it's always got to be 100% owned. So somebody's always got to own it. Now, under the LLC Act, a distribution is made in equal shares among the members. So if there's $90,000, we had a great year, $90,000 to distribute to A, B, and C. Under the default rules of the statute, everybody's going to get $30,000. That doesn't mean it's good or bad, but C, who owns 10% of the company, probably going to be pretty happy with the fact that they're getting more than 10% of the distribution. Member A, on the other hand, may not be so pleased that they're not entitled to 70%. So this is one of the primary things that we discuss with our business clients. Who's going to own what, and how are you going to be paid out in these distributions? But in the absence, this is the rule that's going to apply. My next lesson is discuss, agree, and document. Discuss. Talk about these issues with your partners. I know you're busy doing the business of your business. You're manufacturing, you're meeting with vendors, you're working with your sales team. There's 100 other things to do in an LLC or in a corporation just to pay the bills and keep the lights on. But some of the conversations and the topics that I'm bringing up here today are things that will bring up some issues that will hopefully avoid these divorces down the road. Agree. Agree on these things. Now, you're not going to agree on everything. What color of blue are you going to use for the logo? That's not what I mean by agree. If the business owners aren't going to agree on big picture items early on in the relationship, maybe that should be a red flag, that there's a different path forward for these owners. Because sweeping it under the rug usually doesn't resolve the matter. And when things come back out from under the rug later on, it's not necessarily at a good time. So agreeing on the big picture items is important. Next, document. Write it down. Not only is it a good practice, but it provides for some predictability. And under the new LLC Act, there are some additional reasons to do this. Operating agreement is defined in the Act as an agreement of all the members. That makes sense. Whether or not it's entitled an operating agreement, and whether it's verbal, implied, in a record, or any combination of those. So as a lawyer, this makes me incredibly nervous for my transactional clients and a little excited for the disputes, because this has the potential to really create a lot of disputes. When you can rely on a verbal agreement, memories change, memories fade, people's understanding is different. So to go back in time and to try to recreate that and hold your business partner to it, that can be very difficult to do. So now that the door has been opened up to verbal or implied or some communication in a record, I think it's going to be even more important now for business partners to document what their agreements are. And one tip when you do this, we like to write in a provision where any changes to the operating agreement have to be in writing. So then we exclude all of the extraneous verbal agreements. We've got one document that you sign. The counterpoint to that, or in addition to, understand what you sign. And this might sound like a really obvious one, but I run into well-intentioned, intelligent people that find templates on the internet, and there's some good ones, that have actually met with attorneys and signed off on operating agreements. And 2, 3, 4 years down the road, when they're on the verge of a business divorce and no longer able to communicate and cooperate, we pull out the operating agreement, and lo and behold, they don't know what it says. They signed it because a lawyer put it in front of them. And that's great that you have that faith in a lawyer, but if it doesn't reflect your agreement, there's a chance you're still going to be held to it. So despite the broad definition of an operating agreement, verbal, implied, there's also something called the parole evidence rule, where anything beyond the four corners of the document that contradicts or varies the terms of the agreement is going to be excluded. So the verbal agreement that you come to, that's going to be excluded under the parole evidence rule. Now, there's some exceptions to it that I'm not going to get into, but it's pretty safe to assume that if you sign an agreement, you're going to be bound by it. And I had this happen with a client, again, 2 intelligent professionals who needed to roll some money over from a retirement account. And they met with a very specialized, very skilled attorney who drafted 2 different entities for them and had this nice corporate structure that allowed them to take some of the retirement money and use that to seed the company that they were building. So the party signed it, the lawyer put it in front of them, and one of the parties noticed that, well, this says you're 90% and I'm a 10% owner of this. But she signed it anyways because the lawyer put it in front of her, and wink, wink, nod, nod. Hey, business partner, we're 50-50. We've always been 50-50. That's how we're going to treat this. Great. The problem is 2-3 years down the road, when it's time to find a way to separate these two, we've got a document that says they're 90-10, and the verbal agreement says 50-50. So guess who's got the upper hand in this disagreement? The people that own 90% based on the document. Okay, the next lesson is one of my favorites because I've seen so many different variations of it in the businesses divorces that I've handled. Recognize that a distribution is not a salary. So we're going to work from an example here to put it in context. Salaries versus distributions, and then we also have something called a contribution in LLCs. Now, we're back to ABC Enterprises with A owning 70, B owning 20, and C owning 10. And this is not an uncommon setup that I see, where we've got the money person, like A, comes in with the money, but otherwise doesn't really have much to do with the business. And then we've got B, who actually has a full-time job elsewhere. Let's say they're in marketing. They're going to create the website for the business, and that's in addition to the $20,000. That's what they're going to give the company from the outset. And then we've got C. C doesn't really bring a lot of money to the table, but C is the one in the office working 40, 50, 60 hours a week to build the company. C, the member with boots on the ground in the office, 60 hours a week, fortunately has a spouse that can cover the bills. So they are not receiving a salary. They're not receiving anything. They're really devoting themselves to this company in the hopes that it will pay off for them in the long run. This is their passion project. This is what they want to do. So 2-3 years go by and they make it big. They've got a really banner year and there's some money left over. Who gets it? Well, A, who owns 70%, could argue, I own 70% of the company. I'm entitled to that return on my investment. C, on the other hand, has been working without a salary. And because of C's efforts, the expenses of the business have been down. Had they had to pay a salary for 3 years, would they have had this distribution in the first place? Would they have made the profit that they did had they actually paid C for the work that was done? And this is something that comes up time and time again in different scenarios where either a distribution is called a salary or a salary is called a distribution. And then we have something called a contribution, which is slightly different. That is something that, like the $70,000, that is something you give to the company. That's your seed money. And often it is tied, like in this situation, to the amount of money you put in is tied to your percentage interest. But it doesn't have to be. Under the LLC Act, you can contribute other services, goods, or benefits to the company, and that counts as your contribution. So B, who owns 20% and put in $20,000, maybe they should get credit for the website that they built. Did that increase their contribution? Particularly in the situation with C. Was their contribution all of the effort that they put in? So instead of it being a salary, maybe it should have been a contribution, and now the ownership percentages have changed. So really when it comes down to paying out on the distribution, C owns a lot more. They just did it the hard way. They did sweat equity. So these are all questions that the owners can talk about and discuss because there doesn't have to be one right way of doing it. That's why it's so important to understand what the default rules are because that's what's going to apply if you don't have these conversations. The next lesson I've learned from business divorces is to build off-ramps. Give partners a way to peacefully transition out of the corporation, out of the LLC. Now with a limited liability company, the rules are a little stricter. They are addressed in the default rules, but frankly, I don't think that many people would find the withdrawal, or now they're called dissociation rules, to be something that I would recommend for my client. So take the opportunity to create a buy-sell, to think about how the partners can get out of it when it's time for them to transition. So many of the business divorces that I end up working on are because there is no off-ramp. There is no peaceful way to transition the company. So circling back to a prior lesson about documentation, this is another critical area that you want to document in your operating agreement or a buy-sell agreement, because what you're going to find in the statute is probably not going to be your first, second, or third choice. Next lesson, treat the company like a separate entity, because it is. It is not an extension of the owners. A company can contract, it can own assets, it can sue, it can be sued. So it's important to maintain the corporate entity as a separate being apart from the owners. One of the main reasons to operate under an entity, whether it's a corporation or a limited liability company, is this idea of protecting personal assets, protecting you from personal liability. So you've got the corporate form there, whether it's the LLC or the corporation, and that stands between potential claims and your personal assets. So if you are not treating the corporation like a corporation or the company like a company, that gives a crack in the corporate shield and an opportunity for someone to what we call pierce the corporate veil, where we pull it back and we look and we see that individual, that owner, is not really operating this company the way it should be. And judge, don't honor that corporate form. Let us get to those assets. Unfortunately, it happens. So in addition to meeting with your CPA and getting your books set up properly, keep in mind that this is also a way of protecting yourself, your assets, and your family. So don't overlap your personal funds. Don't commingle with the business. If you put $5,000 into the business account, write it down. Was that a loan? Was that a contribution? Because at the end of the day, when we open up the books, which we always open up the books in these business divorce cases, are you going to have a clean set? Are we going to be able to document that you treated the company as if it was a separate entity? Next lesson, don't overlook the spouses. And this time we are talking about marital divorce in part, because Arizona and many other states are community property states. And I'm not going to get too much into family law, but let me say that in a community property state, even if a spouse, a married spouse, is not listed in your operating agreement or on the stock certificate, they may still have an interest in the company. So don't overlook the spouses. In your operating agreement, you can address whether or not an owner owns as his or her sole and separate property or as community property. And then think ahead beyond today, tomorrow. What happens if they do get divorced? And we've got an owner that maybe comes in or that gets a new share of the company, or, heaven forbid, a spouse passes. The owner passes. Does the spouse then step into the shoes of the deceased owner? No, the LLC Act does deal with it. There's some provisions for that. But again, it may not be the way that the parties intend. I've had it happen. It was very unfortunate. Two young business partners had a great thing going, and one of them passed unexpectedly. So the wife stepped into the shoes. Now, we never really challenged whether or not that was appropriate. The remaining business partner tried to find her a place, tried some different positions within the company, and it just didn't work. And he ended up buying out the deceased husband's interest in the company. So it does happen. We'd like to think it doesn't, but it really does happen. And the next lesson I've learned from business divorces is acknowledge that evolution happens. Things change. We talked about off-ramps before for people exiting the company. But the company also is going to change. Your product's going to take off. You're going to open up a new product line. You're going to reach into new markets. And maybe you've brought some new owners in. So it's not enough to draft your operating agreement and to put it in a drawer. Because when you pull it out in 10 years, even in 5 years, things may have changed drastically. I worked with a client who had something very similar happen. It was a partnership agreement between two people. And it was a one-pager, and it dealt very high level with how people were going to vote. Well, over the years, they added members, They expanded their product line, they looked into new markets, they brought in more members, and now we're to the point where the partners need to find some resolution because they are unable to continue to operate the business together, and we're looking at a partnership agreement that is not applicable. It just doesn't apply anymore. And of course, we've got a writing, so we need to acknowledge it, but things have changed so much, it's just not useful anymore. And my next lesson, forget the meat slicer. And this one's going to sound a little odd, but focus on the big picture. Oftentimes in a business divorce, I find that one member may fixate on a particular issue, whether it's, I had a case where it was a meat slicer, and this really becomes a lightning rod for all of their issues. Maybe it was the business trip that one partner took to Hawaii when the other was trying to be frugal with the company money. There always tends to be one thing that really serves as a lightning rod. But when you look closer, there's either underlying issues or that's the thing that people point to so they can explain these other issues going on within the company. So for the sake of your partners, maybe take a step back, and before you want to fight over the broken meat slicer, think about the big picture. Think about your business partner. You've been with them for a while. You've brought in new members. This is a great, booming business. Is that meat slicer really worth fighting over? So at the end of the day, it really is about the big picture. And you don't get to the big picture all at once. It starts at the formation. It happens along the way. It happens through conversations and documentation and writings with your business partner. It happens by understanding the defaults so you can talk about how to structure your business in a way that meets your needs, that allows you to succeed in what you're doing and to pursue your passion and innovation. Well, thank you for having me, Moonshot. Thank you to the crew for making this an enjoyable morning. And for any of you, whether you're starting out in your business journey or you're well on your way, if you've got any follow-up questions, because I know I threw a lot at you today, feel free to contact me at awdlaw.com. I'm happy to speak with you.